Welcome, everyone, to the June 14th meeting of the Charter Commission. Welcome to the summer session. We'll start out like we always do with a call to order and roll call. If you would be so kind, Janice.
Okay, Ted Trainer,
Here.
Chris Babbage,
Present.
Janice is here, Brenda Robinson,
Here.
Durwood Parkinson,
Here.
Richard Smith,
Here.
Susan Bloomfield,
Here.
Christian Babcock,
Here.
Stephen Sayers,
Here.
and I see we have Natalie Burns, our town attorney, Heather Balser, our town manager, and Merton Brenn, our town clerk, with us tonight also.
All right. Thank you very much. We'll move right on to section number 2, public comment. Any members of the public wish to comment on anything? And we'll always give chance to comment as we go through. So, all right. Moving on to old business. Last time we reviewed the proposed recall article section 7.03 and 7.04 in detail and collected commentary. Janice and Stephen prepared changes and circulated them to the commission for review. And tonight, I hope to plow through the recall article. We're going to try to time box sections 1 through 4, subsections 1 through 4, because we've already been over them thoroughly. And hopefully we can move through that and then get on to .05 and beyond at tonight's meeting. Any comments on old business before we move forward? Yeah, go ahead, Merton.
Yeah, one thing that we need to talk about is the 9 months
Yes.
is approaching us, so would just, maybe Natalie could tell us what the process is to, I mean, I know we have to go to the
Yep.
board to get it extended.
Yep.
But is there a process, Natalie, probably?
That's okay.
Sorry I sprung that on you.
Yeah.
Hey, you did spring it on me. And I'm not quite organized yet, but I do believe that what you need to do is you need to request the select board to give you additional time in which to proceed with your work. And why don't I come back to you with a better answer than that in a minute or two?
I would love that. And I had spoken with Dick about this before the start of the meeting, and, you know, we were of the same mind that I would draft up a report with a request and kind of report on progress as where we're at and have that to the select board no later than the beginning of August so that they can review it and get it on agenda and review it in time for approval.
Yeah, and just remember, they have a very abbreviated schedule in July and August.
Slackers. Kidding. Yeah. I say that with the select board member present, so. All right, cool. So I will take that action item to start drafting a correspondence with them and craft a report on where we're at.
And you pretty much have discussed what needs to be done, but what the statute says is that the municipal officers may extend the time limits, and as you know, that's 9 months and 12 months, for the preparation and submission of preliminary and final reports of the Charter Commission for up to 24 months after the election of the commission.
Cool. Thank you. All right. So new business, recall article. Janice and Stephen had circulated the updated draft about a week ago, or maybe even more. I'm losing track of time. So Chris Babbage, yes?
No, I was just going to say, review recall. I'm sorry. At the conclusion of the last meeting,
Yep.
Durwood said something which prompted Ted to say something, and then you said, Chris, will you come up with some wording for that?
Yes.
And so I think the discussion was about, is this on? I'm sorry. I think the discussion was about trying to make vacancy and forfeiture straightforward,
Correct.
and recall relegated to more subjective evaluation of wrongdoing.
Correct.
And so So I did come up with some wording to try to streamline vacancy and forfeiture.
Yep.
But what that does, because remember what our choice is. Our choice is new or current. That's our choice. I mean, that's the voter's choice. So if they reject what we have, it reverts to the current charter.
Correct.
So we do have to refer to that once in a while to see what is in the law right now. And that's included. So as far as our decision-making on what I just passed out, it's really the first and back page. But I said what follows is wording that streamlines vacancy and forfeiture and then leaves disputed malfeasance and subjective decision-making to the recall procedure. But, I mean, take a quick look, if you would. For instance, let's look at vacancy.
Hold on.
Okay.
Because we're not talking about forfeiture of office, so
Okay.
if,
But-
tonight, but, go,
Let me
okay,
tell you the relevance.
okay,
The relevance is what we currently have under forfeiture
yes,
is not cut and dry.
correct.
So perhaps those should be inserted into the recall portion of that. That's
Okay.
where I'm going with this.
Gotcha.
If we streamline forfeiture, then we have to make a decision on those things that are more subjective. Do we merely omit them, or do we put them under recall, if we choose not to include them in forfeiture?
Okay.
Does that make any sense? You know
Yes.
What I'm saying? Yeah, okay.
I understand.
So that's the relevance to recall, that's all.
Okay, I got it. Ted?
Yeah, I want to support that at the risk of having it yet look like we're going back and inventing the wheel. We've been all along unclear about just this distinction. And and so it would be nice to be able to say, okay, let's get the cleaner language and forfeiture done, then we can think more clearly. But right now, if we go through as we plan and say, okay, recall, well, maybe that should, we'll be kept in our mind going back and forth. And so
Yep.
and we've been doing that.
Yep.
And working towards a solution. I think I haven't read it.
Yeah.
Well, nobody's had the opportunity, and I don't want to apologize for that. I have had an amazing few weeks. But, Chris, the only thing I would ask is that everybody read this.
Yes.
And the only thing I think that would be helpful, if we do discuss it at all, would be to help Janice and Stephen have direction as to how much to implement this into
Sure.
the document that we're using.
Yeah. I will point out that this was handed out to, you circulated this right at the beginning as we were all sitting down. And so obviously no one's had a chance to review it. And since it is heavily based on forfeiture of office, which I hope we can revisit next time and hopefully put a stamp on that. That's my hope after going through recall tonight. If that changes things for recall, then subsequently we can hopefully amend our recall discussion tonight with that. But I think.
So recall is the second half of that, because I tried to
Correct.
insert it.
Yep.
But I do want to recall you asked for this document.
I did. Yeah.
I would greatly have appreciated if you had not asked for it
Oh, okay. Well,
in the last few weeks. But anyway, it's there for us to look at.
thanks. All right. So, recall, everyone have their recall drafts. There's copies of them over on the document buffet. We'll start right at the top with section 7.01, right to request a recall election. Comments and questions, concerns. Trying to keep it concise, as we've already gone through subsection 1 through 4. If none, I will move on to section 7.02. Section 7.02, grounds for recall of elected official. So grounds were updated, amended to include C, D, and E, malfeasance in office, misfeasance or nonfeasance in office, and a conviction of any qualifying crime as defined in the definitions set out in Article 2 of this charter.
Is there a definition?
Is there, that's a great question. Go ahead, Susan.
Yes, malfeasance, misfeasance, nonfeasance, and qualifying crime, those have all been defined in the definitions list.
That
Which was sent
circulated and
to-
is not part of this document, but
Right.
that should be in your email.
That was sent on Monday.
Rather than set forth an elongated definition in the charter provision itself, as we were discussing this and how best to eliminate potential ambiguity, we both decided that it would be better just to enumerate as a broad category what would constitute a valid ground for a recall, and that's why we added those three right at the end. That malfeasance in office, obviously there's a degree of fault associated with that. Misfeasance or nonfeasance can be unintentional and not necessarily fault-based. And I just used the formula of a qualifying crime in section E. As I was thinking about that, maybe it should be a specified crime or something like that, but some description of what it is, and then there's a fairly extensive definition of what the crime would be in the definitions section that was circulated. And we specifically extended that to a crime committed in any jurisdiction in the United States, not just Maine. And even though the Maine rule of evidence allows evidence of a crime to be introduced if it has been committed within 15 years. We thought, based upon Ted's comment, that was a little too long. 5 years, a little too short, and we came up with an arbitrary figure of 10 years, which seemed fair. And then there are certain provisions of the Maine rule of evidence regarding, for example, juvenile crimes, and we included some provisions tailored from the main rule of evidence to accommodate those. But that's why we took out a bunch of long language and we put in just three short categories.
All right. Questions, concerns, comments? Going once, going twice. All right. Section 703, performance of an elected official's duties is not a valid ground for recall. One sentence subsection. We did talk about this last time after I suggested we move it up top and said, nope, it's good there. Questions, concerns, comments? Stephen?
I haven't had the time to read Chris's piece yet, but he suggests that
There you
I
go.
haven't had the time to read Chris's comments yet, but he suggests that the title of this provision of Article 7 should be changed to be an elected official's decisions made in the proper performance of his duties are not a valid ground for recall, and I think that makes sense.
May I?
Go for it.
The reason that I thought maybe that could be confusing if we don't do that, because we say that we don't want the decisions made by an office holder in the proper carrying out of his duties to be subject to review for a recall. That's not grounds, according to the consensus of this committee, for cutting a term short. But, thank you very much, but performance of duties, we have just talked about malfeasance, misfeasance, nonfeasance. We've, in our current forfeiture provisions, we have incapacity, we have incompetence. I mean, those are performances. So that's why that term, I think, unless we try to carve it carefully, could be a contradictory. Thanks.
Understood. Go ahead, Dick.
Could you read?
You're not on mic.
Chris, could you tell us again what you changed it to? And do you have that written down in your
I have it
missive?
right here. I can read it.
That is under recall in the handout that I gave you, which must be on the third page.
It is on the top of the last page, Dick.
Okay, so
Last
third
page.
is
Yeah,
where it
right at the
starts.
top. Proposed.
Okay, good. Let me,
An elected official's decisions made in the proper performance of his duties, would make the suggestion to leave it as their duties, are not valid grounds for recall.
Well, elected officials then would be a different apostrophe S if you're going to change the pronoun. I had a singular, but it doesn't matter.
Got it. So I think Stephen said that that was amenable to him. Ted, go ahead.
Yeah, sitting here with this artichoke you all gave us, and every time we look at something, there's another subtlety that we hadn't thought about. This was the subtlety I hadn't thought about, and so once looking at it, I said, yeah, we got to do it this way.
Yep. Cool. Other questions, comments, concerns about 703?
I
David?
had one thought, and that would be, and I'm not advocating this, but I would say, looking at the actual language, disagreement, no matter how vehement, over an elected official's exercise of discretion. That sort of is a little emphasis, but who's going to be applying this provision? It's going to be a court. And there are going to be pretty vehement expressions of disagreement with an elected official's exercise of his or her duties. And so that might be an appropriate way to emphasize that this is not intended as a substitute for the proper exercise of discretion. What do you think about that collectively?
I like words. Vehement sounds good. I agree. It indicates that, that we're not, no matter how passionate a person is or how right they feel they are, it's not a matter of passion. Cool. Ted?
One wrinkle on that, that does sort of bring up the issue that the vehemence with one presents something has an influence and impact on decision-making. And that I was sort of thinking, you sort of want to avoid that, and say, well, someone, the louder they yell at shouldn't have any impact on decision-making. This does sort of admit the reality that it does. And so
But it does.
and you're saying in the court of law, well, you're a lawyer, you've been those experiences. I only see them on television.
Right.
I think it's a good addition, especially given that I think 703 is kind of another context setting paragraph after 701, and like 702 is kind of the meat and potatoes, but you've got section 701, which kind of sets it up, and then 703 kind of caps it. And then I think we get into process. So, Chris, I saw your hand up.
Well, it is under recall, but
Your mic, I think.
relating to the recall provision and Stephen's, I think relevant point. But can we look at 701 and that very same evaluation? And perhaps you'll disagree with me, but I thought we were getting a little preachy there about, an election opens up potential for targeted, criticism, damage to reputation, all of that. That's what an election can be, because you're offering yourself out there for criticism. I tried to make it a little more businesslike. So in 701, this is in my document in the third page in the bottom, it said recall elections. And then instead of all that elaboration, which kind of refers back to the harm that was, I have no reason to doubt, was imparted in the last recall. Recall elections implemented without strict parameters is the new wording that I had suggested, have potential for abuse, divisiveness, controversy, and harm to reputation. Without elaborating, I think that's in a business-like way that covers the negatives that can be associated without the wordiness of the rest of it. That is more explanatory, but I'm not sure it's so we are putting in strict parameters, and that's why it goes on to say, in Stephen and Janice's wording, it shall be the policy of the town that the right of the registered voters shall be reserved exclusively for the following situations. And I think that's great. But I thought we were being a little more direct and accurate by merely saying recall elections implemented without strict parameters have the potential for abuse, divisiveness, controversy, and harm to reputation. I mean, that does tell what some of the negatives are if it's not directed as to how the procedure should be done. And so, I don't know, I offer that, but that's kind of going in the other way because I prefer direct, objective wording rather than flowery reflections on the past.
I don't disagree. I don't think the change is substantive. You know, I think it's tone, right? So I'll leave it up to Janice and Stephen. If you want to incorporate that language and bring it back, that's completely fine.
Thanks
If you
for
have an
letting me-
opinion now.
Thanks
but-
for letting me bring it forward.
Yeah,
Frankly, I don't see that there's a substantive difference.
yeah.
I mean, you've added a couple of words.
And take it
You
away
haven't
from you.
really taken away very many, and elections and recall elections are substantively different. An election doesn't necessarily involve someone's reputation. A recall election always involves someone's reputation because they're being accused of misconduct. Their reputation is centrally at issue in such an election, and it seems.
Yeah, I would say all elections are an evaluation of character.
All right. I'll leave it up to Janice and Stephen to take it under advisement. Susan? Yep.
And I would like to ask, as part of the review of Chris's document, Chris offered another definition of recall, and I believe another definition, as far as I've seen so far, of forfeiture. If Janice and Stephen could take a look at those and just let me know which one wins, then I can add it to the list of definitions, because I think we're up to three now for forfeiture.
I want to make it easy because I created that definition and it was not a correction of any existing definition. So read it for what value it has, but if the current one is better, I'm fine.
Okay.
All right. Any remaining comments, questions, concerns on 703? All right. 704, notice of intent to request a recall election, intention. This was where we left off reviewing last time. And this is to refresh everyone's memory, we got into discussion that spanned recall and forfeiture. This was the section that caused us to kind of go back and look at the process around forfeiture. And kind of say, I think my closing comment on that was that recall is a tool of the people, and forfeiture, the way it is was written in the draft by Janice and Stephen, is a tool of the select board to ultimately, or the legislative body ultimately, to implement. And that was kind of the line in the sand that I saw of where things should land. So, any questions, comments, concerns with 704? Go ahead.
Does that come into the periodic review that comes in 713? I mean, because that's got the numbers in there.
Come into the periodic review of 713.
Yeah, that talks about review every 10 years,
Oh.
and about the
Yeah.
registered voters.
Yeah.
And maybe that should be back in 704. I don't know.
Since we're using specific numbers instead of a percentage of the voters who voted in the last gubernatorial election, it was my view that the population of the town could change significantly, and that might affect statistically the effect of the 500 registered voters requirement. Probably not. It would take a pretty significant increase or decrease, I think, in the population of the town to make a material impact upon that 500 figure. But that's the thing.
Yeah, I totally understand and agree that there's got to be some double checking of that from time to time. But is that the only concept that's involved with a periodic review under 713? So maybe it should be moved into 704. And then also, who's it reviewed by? I mean, do they get the band back together or is it the select board, or who's town manager? I mean, who's doing the reviewing? And was it 10 years from the effective date?
Yeah.
Right.
I'm gonna jump in because I'm gonna ask Natalie and Martin a question about, is there any statutory regulation around reviewing the charter on a 10-year basis? I know I'd read that in a few
Sounds like the
charters.
select board.
There is nothing in the statutes that require it, but you're right that many charters do have provisions on it. And I would ask you, as you review this, to determine whether, and this relates to Derwood's question, this talks about, if necessary, a new charter commission may be appointed. Remember, it's appointed and elected. But is that who you want to make the determination about the number? Because otherwise, this would be a single topic thing that could be the subject of an amendment. But do you want the select board or the governing body at that point in time to have the authority to recommend changes to that? Or would you prefer that it come back to a charter commission?
Right. Ted?
I was thinking that issue of numbers is a technical issue and would be a responsibility of the town clerk to say, okay, this has come up and the numbers have changed, and to bring forth the issue. I mean, it's not a big
Yep.
charter thing. It's a very important technical issue.
Yep. I'm gonna make a note and say we back burner 713 until we come to it. Go ahead, Chris.
I just want to share that the knee-jerk response of an elected official in a town the size of Kennebunk is to have a petition of intent to have a recall, have 5,000 signatures, and have 10,000 signatures to make it a recall election. I mean, there's no incentive to make it easier by a sitting incumbent. So, I mean, that's just, who wants the headache of that? So it seems to me to have an objective commission without an agenda on a periodic basis reviewing the charter as a more responsible group than even the creation of a charter based on a crisis.
Yeah.
I think that periodic review is wise, and honestly, I think there is a philosophy about town meeting that is right or wrong, but it's kind of Jeffersonian. It said if you get a certain number of people together, regardless of the number, if you get a minimum number, that whatever that threshold is, the wisdom of the collective is going to be met. And so 2,000 signatures and 500 to get there. I think we've upped the ante a great deal, and I think that's wonderful. I think it's a good change. And even if our population goes up 25%, those numbers are not easy to attain. But a charter commission at some future time could decide to amend that, I would think. But that's my 2 cents. Thank you.
Yeah, I would back burner it as something maybe we elevate like many other towns do with their charters, and have a requirement to, review the charter on a certain basis in totality. And that gives the leeway for a charter commission to be formed to address this.
Chris?
Yeah, go ahead, Ted.
I'm in complete in favor of that. I was speaking to the particular issue of the 500.
Right.
As a piece of that, I'm completely in favor of putting in a proposal for, or in the charter for a 10-year regular
Yeah.
thing. It's a different issue to me.
Yeah. All right. Other questions, comments, concerns on 04? Go ahead, Stephen.
No, I was just going to suggest that if, obviously, section 7.13, there would be a completely different provision that would be in a different article, not just the recall article.
Correct.
Before general, review and amendments in the future. Okay.
Yeah, I think it goes in the administrative 8 or 9 or 10, something like that. 04, going once, going twice. All right, moving on to section 705. So now we are into non-reviewed recall article territory. So anyone want to kick us off? Or maybe there's no comments. Petition for recall election. Go ahead, Dick.
When you, the third paragraph down, which is the short paragraph for purposes of this article, there are two separate documents, and signatures appearing on one may not be used as a substitute or in place of the required signatures on the other. I think it should be made clear that there's people who sign the original petition can also sign, their name can also appear on the recall petition itself. And this is a little bit unclear as to whether
Right.
the names can appear. I understand you can't substitute one document for another, and that's clear. But I think it should be made clear that, that your name can appear on both of them.
Yep.
If they're written on both of them. So that's my
Yeah,
one comment there.
I think we probably need to look at the wording. The intent of that, Dick, was that we didn't want somebody who had had the notice of intent signed to come back with that and say, well, look, these are done already. I don't have to do this many for the actual petition because I already have them on this. So if you guys can think of a better way to word that, I don't want them gaming the system thinking they could use it for a second purpose.
Right.
We want them to start over again.
Yep.
With the petition from scratch after they've gotten a notice of intent taken care of.
Yeah, I think that's very clear, that they can't, like, just take the original intent and slap it on the first 10 pages and say, okay, we're gathering from here, but I think Dick's point is well made in that just a clarifying sentence that follows it says, signatories of the intention may sign the petition.
Just something like, but qualified inhabitants of the town, signature may be on both documents and count as valid signatures on both. Something like that.
Okay. We'll work on that one.
Other questions, comments, concerns? Gail?
Gail Spofford, Kennebunk. I have a concern about the fourth paragraph down under 7.05. If the expiration date falls upon a recognized national or state holiday or upon a weekend, then 4:30 p.m. on the next occurring business day shall be the expiration date. That could conceivably provide 33 days to acquire signatures.
I can address that. Stephen and I discussed that in quite a bit. The only real practical way to avoid that is to actually change your 30 calendar days to 28 calendar days.
Or,
And that way, if your desire is to have 30 days, and that way you account for it, because otherwise, yes, it does build that possibility in. So that's a structural issue that we probably as a group need to decide. How strict do we want to be? Do we want to give them an extra 3 days? And we need to back up to 30 to 28. So it comes out with, you know what I mean?
that would only be if you knew it was going to land on one of those days and it included all 3 days. Monday, holiday, Saturday, Sunday, Saturday, Sunday, Monday. I'm wondering if there is a potential for it, depending on when the notice is provided, if the clerk who's going to be giving these out and notifying them of the 30th day could potentially withhold the petitions first day one, until such time as it would never go beyond a Friday when the town hall was open.
Well,
Go ahead. Stephen, if you've got, I see a lot of hands on the mic, so go ahead, Stephen.
It seems to me that that's a somewhat problematic suggestion, and you have to ask yourself how likely is that actually, how likely a scenario is that to be envisaged. And I understand that we've been through that, but that situation, the past situation, involved arguments that about the specific date, that date should be extended. And the one way that we thought of to try to inhibit maneuvering of that type would be to make sure that the town clerk is the one who determines when that 30-day period expires. And then he or she has to note that actually on the petition itself, on the face of the petition. And so that, you start out, when you're given the petition, there's going to be the expiration date right on that petition. And so that eliminates any sort of after-the-fact maneuvering as the 30th day sort of approaches, which is the kind of arguments that were made in the last recall election.
But if it's sitting on someone's, if it's in someone's hands on a date when it would be returned, say, on a Saturday, that person could still go get signatures. I'm not saying they would. But I've experienced a recall, and I have knowledge of some of the activities prior to the recall. And there are some people who will take advantage of it. And as it is a direct insult against the person who's being recalled, I think we owe them some leeway. And I'd be thrilled to hear Natalie say why the clerk couldn't decide that day 1 to day 30 would never land on a Saturday, would never land on a Sunday, and would never land on a Monday holiday.
My response to that would be that the clerk cannot be given discretion in these things. If the charter says that if someone does something, then the clerk has to issue documents for it. The clerk has to issue documents for it, and it's not a question of the clerk deciding when to issue the documents. The clerk issues them as soon as it's determined that they've met the requirements for them. I think as a matter of state law, it would be very problematic to have a charter provision that said otherwise. The
Okay,
clerk-
so that's state law.
Yes, yes. Well, it's not expressly stated in state law, but I think it's very much implied that town clerks do not have a lot of discretion in election matters.
I think that the numbers you've applied to this will avoid some of what happened before. But I just have to say, the activities prior to even getting the paperwork out indicate to me that the character of the people who might present a notification and then a petition for recall might be those people who would violate and use those 3 days. And there really is no way that you can monitor that. I just want to leave that on the table. But thank you, Natalie, for letting me know that.
Thanks, Gail. One thing I'll point out that occurred to me after we met last time, and it was in regards to a back and forth that Brenda and I had about process and forfeiture, is something I think we often get is, as we're going section by section, is blinders to the overall process, right? Where this is a very big process, and when we hone in on like one section, 30 days, we say, wow, that's you know, a potential hole we could step in, right? And but then you look at the totality and say, well, there's still a really high bar. They have to collect 500 signatures for the notice of intent. They have to collect 2,000 for the petition. That we've got, I think, a lot of other safeguards built in to the overall process, so that hopefully a single piece won't break the camel's back, or a single straw. Ted, Chris, Ted, and then Brenda.
Gail, I appreciate your points. These are important points, and this was part of the mess at the recall, and you know that very, very well. At the same time, this is really important that we protect the integrity of the process, and that is the town clerk. And then the problems we got into included things that question the town clerk and involve the town attorney, and that we want to make absolutely clear that that kind of thing cannot happen again. That kind of ambiguities and things you were subject to. So that's really the important part of this. That may still lead to some maneuvering that might happen, which is what did happen. But also what happened was the integrity and the process in the town hall and the government was attacked, and that we cannot have. That's my own view.
Chris, did you have something?
Yeah, I appreciate the discussion.
Your mic, Chris.
Thank you. You know, the town clerk is immensely important to this entire process, and we really, I think, are unfair to the town clerk if we allow him the discretion to be criticized by anybody that happens to be disadvantaged by his decision. By including recall in this charter, we are endorsing a procedure. And we're saying it can be legitimate. There can be people who should be removed. And therefore, we are providing a vehicle. So to make it artificially harder or whatever, sometimes might be want to be rooting for the person. We just need to narrow it. I'm scared to death that we are entering an arena of politics where elections will merely be step one and recalls will be an automatic second-year experience. That would be horrendous. And so that's our task, to try to make that impossible. And I think we're on the right track and doing a good job with that. But I think we want to be careful that we're not putting something evil into practice if we do this right. So, thanks.
Thanks, Chris. I got Brenda next, and then I think I saw Durwood.
I think Chris just set the stage for what was running through my mind, and we don't want evil anywhere. I'm just wondering, from a voter's perspective, is a two-step process with such high numbers going to set people off? That's a really cumbersome process where you have to go through an intent with 500 signatures and then a recall with 2,000 signatures. Are we going from the sublime to the ridiculous? Am I making sense to this?
You're making sense. To me, I understand.
I just wonder, from a voter's perspective, I think everybody, not everybody, but a great majority of the people support revision of the recall process. Are we just going too far? And I just put that on the table for discussion.
Merton, did you want to respond?
You know, having gone through this, I really have to say that I think that the high numbers definitely match the seriousness of the act.
I wasn't questioning the numbers. I think the numbers are great. It's the two-step process.
Well, there was a
where-
two-step process before, too. There was an affidavit process and then the
Right.
petition process.
Okay,
Yep.
okay. I think the numbers they're okay.
I mean, the numbers, I think, speak to the seriousness of it, where the affidavit and the other process that we went through really didn't. And I certainly never realized how serious the whole event was until it got the way it did. And, you know, I'm not sure that they don't all end up that way, but it was really my first exposure.
Go ahead, Susan.
And I believe that we had decided that the numbers are not unobtainable if there is an egregious violation of some sort that would warrant a recall.
Yep.
So it's not, they're not by any means outlandish.
Yeah. I had Durwood next on the docket, then I see Ted's hand up. Durwood?
I know we've talked about this before, but I wanted to go back to the method of counting. I mean, in the legal world, the day one is the next day. And, you know, when I'm looking at a purchase and sale agreement, it says 14 days to do inspections. I'm not counting today, the day we sign the contract is day one. I mean, the changing day one is the day that you receive the notice seems strange to me. That in effect, what you're doing is you're eliminating a day. I'm not saying that the days, you know, maybe should be 20 days or something. It could be shorter or longer, but it just seems like the more conventional way of counting is to start from the next day. And I know that's true in the the courts, the federal courts, and in real estate. I've never really seen something that day one is the actual day, because the whole day hasn't elapsed yet. You know, it elapses the next day.
Understood. You know, I would respond to that with, you know, Merton gets in at 7:30, notifies the petitioner that they can come pick up their forms, their petitions, and then they go out and start hitting the pavement and collecting signatures on day zero. And, you know, if,
Well, that's day one, the day he gets the petition.
so,
Regardless of the time.
Yeah.
unless,
Say if he gets the petition at 4:15,
Yep.
that's day one. You've already lost a day.
sure. And I mean, and I'm only saying that as pointing procedurally that
I mean,
maybe put in stipulation that petition shall be issued at, you know,
my only
I don't know.
suggestion is that we do what is more kind of commonly accepted in the, you know, the legal world or the business world in terms of counting. I just haven't seen
Yep.
it. I mean, somebody can prove me wrong on that, but
Sure.
I just haven't seen that.
Thoughts, Stephen, anyone?
Does it really make a difference? The fact of it, you've got to use some specific mechanism to decide when the expiration date. It's really not the initiation date, it's the expiration date that you're
It
focusing on.
doesn't make a difference, except that it could cause a controversy because somebody just said, well, I counted the days, and then, you know, they didn't read it, and it could create I mean, because I think the walking around understanding of counting is what I was saying. I mean, it doesn't make a difference if you name the rules, you know, and make them of the game and make them clear, but I'm just saying these rules aren't sort of typical. I mean,
Ted, Chris, go ahead, Ted.
This timing thing was what part of the problem that came up last time.
Correct.
So I would appreciate the expert view on that issue. The other one, Brenda, everything we do is going through public hearings up the wazoo. And so if, as we go through our own process and after our report, and so we'll get a pretty good read from the public before this report is finalized. So I think as long as we articulate what we think is right, and then if we have to adjust because 3,000 people come in and say we're wrong, then we can do that at that time.
Chris, did you have
Yeah,
something to?
I had it on, sorry. I appreciate Dewart's comments. I think if our worry is that we're giving an extra day, I mean, like I said, I think that's the wrong attitude, but if that's the case, then shorten the number of days. But why have a procedure that's contrary to what's legal and used in the courts? I mean, it's just 24 hours is a day. If you give it to me at 4 o'clock today, I have till 4 o'clock tomorrow. You know, some people might be notified by Merton at 9 o'clock, but if they're at work, they'll pick it up on the way home. I mean, I'm just saying facility. This is not a major question, because as long as you have it on the document, it's legal and we can do it the way we want. But I do think, why be different for the sake of being different? Yeah, so.
Susan?
I think Stephen maybe was alluding to this. It's the expiration date. I think it's critical. You know, if you show up at 8 o'clock, bright and early at 8 o'clock and get your document from Merton or whomever, you have that day. The expiration date is still going to be the same. If you show up at 4:15, too bad on you. But the expiration date is still the same. And I think that date is really critical one, and that was the one that was goofed up.
Yes, Chris.
Help me to understand when the date kicks in. Is it the date of Merton's announcement?
Yes.
That it's available?
That's what's currently
Even if a
written.
person's in England?
Right.
You're saying
As is currently
it's
written,
not
day one
when they,
is
it's not when
the,
they receive the document?
as is currently written in the draft right now, day one is the day that Merton notifies someone via email, it is specified, that their petitions are ready.
Again, the focus is on the expiration date. That's the only date that really the petitioners are going to be interested in. And Merton gets the town clerk gets the job of deciding what is the expiration date. Her decision is not subject to debate, and her decision regarding that date gets put right on the face of the petition for itself. So everyone knows right from the get-go when the expiration date is and when they have to get that thing filed.
Okay, Gail, yes.
Gail Spofford. I just have a general format question. At the last meeting, I thought you said that you were going to try to have another workshop for the public.
Yep.
Okay, so you would be able to address some of this before you actually go to the hearings?
Oh, yeah.
Okay, good. Thank you.
I would think so. I mean, maybe Ted was using public hearing loosely, but I think the idea was we would have another public hearing, meeting, whatever you want to call it, where we solicit input from the public after we get something drafted and ready for circulation, so that, feedback can be collected in person. All right. Yep. And just for the record, all of our meetings are public, and anyone can come and comment at any time.
Joan Honeywell, Kennybunk. I have maybe a solution to the issue of the email versus the pickup versus your 30 days. You send the email out saying the petition is ready to be picked up. That person takes 3 days to come get it. Their start time starts the day they pick it up. That's when their 30 days or 28 or whatever it is you're counting gets done. Because otherwise, if you send this notification out at 4 o'clock, because you're busy all day and you haven't had a chance, they've now lost a day. And I understand that the recall's, been problematic and everyone's upset about it, and especially if you were subject to it, but I'm not sure making it harder is going to make it better. You've already got 500 people who have to agree. You got another 2,000 that's got to sign off. Is really another day going to make a difference?
So, thanks for the comment, and I think the problem with the proposed solution is by allowing the petitioners to select when they want to pick it up, effectively gives them the leeway to dictate when it could or could not be due. And really, I think the point that's now been made a few times is the important thing is the expiration date. And I'd like to believe that if someone has gone through the process of getting 500 signatures, then collecting another 2,000 signatures, that they are going to make every effort to at least pick up the petitions the moment they're ready, so that I guess they haven't collected 2,000 signatures. Pick up the petitions the moment they're ready, so that they can get underway with collecting 2,000 signatures within their 30-day window. So I appreciate the comment, but I think the problem with that, allowing them to pick it up and then starting the timer, just gives too much leeway for things to go wrong. Go ahead, Chris.
That leeway would be eliminated if we made, I suppose, if you go by our current definition, it starts on day one. Well, actually, I like Durwood's definition, but my point is, if they pick it up on a Wednesday and you say 28 days, and we use Durwood's definition, that means it's due on a Wednesday in 4 weeks. That works. The only way it can be manipulated if somebody purposely picks it up on Thursday or Friday, has 30 days, and it goes over to the next Monday. But eliminate that possibility if you want to. Make it, you give it on a Wednesday, it's due on a Wednesday, 28 days.
Yeah, I mean,
Well, it's 28 days depending on when you start. But, yeah.
You know, as soon as Merton notifies, the responsibility is in the hands of the petitioner, right? The ball is passed to them. And, you know, if they want to burn days, you know, that is their decision. The expiration date doesn't change because, by the way the process is written right now, Merton has notified them. There's a date stamped on the petitions, and you have, that's the due date for your homework. So, Dick, then
Yeah,
Brenda.
It seems to me that as long as the date is put on the petition by Merton, that there can be no ambiguity of when it's due.
Correct.
And if they, as you said, if they choose to go to the Bahamas for a week, that's on them. Let's see how, you know, are they serious about
To a family funeral in England.
prosecuting their agenda or not? It just seems to me that this is as simple as we can make it. And the only other way would be to have Merton work on holidays and Saturdays and Sundays to come in and collect the petitions, but that doesn't seem to make any sense to me.
Which he would probably agree.
Which he has done and would do in the future, I'm sure.
But
Yeah.
this is clear,
Yep.
concise, and I see no ambiguity.
Brenda?
I think you said it all.
Okay. Questions, comments, concerns about 705 that we haven't already covered?
Okay, let's look at it again.
All right, hearing none, moving on to 706. Certification of the petition and notification. Questions, comments, concerns? I'll start. I appreciate, on behalf of Merton, that 20 calendar days are given to certify. Merton, I think you, when you
Yes.
were certifying the last ones, I think you and your staff were at 400 hours or so.
Yeah, and I think the former one gave us 5 days.
Yep. Yep. So,
And of course, this is far more signatures too, so.
right.
Yeah, but 20 days I think would work well.
Yeah, and I know you worked with Janice and Steven, so if you feel like that's adequate, then I think that sounds good. Dick?
Down in the, I'm sorry, I just went into section 707, so
Oh, okay.
I will withdraw that
All
until
right.
you get there.
No worries. 706. Oh, you want to go back to 705? All right. I'll allow it. What's up?
I officially apologize to everyone. I had a note to myself regarding it was the last paragraph of 7.05. How would the agent know how many signatures are valid and necessary if people are coming to the town clerk's office to rescind their signature on the petition? It seems that is a moving target.
Well, here's how I read it. I think the key is the last sentence, and correct me if I'm wrong, Stephen or Janice, but basically it sounds to me like the town clerk will receive written requests to remove up until the expiration date. Those requests will be put in a request bin under lock and key, and then will be, not under lock and key, it's not specified that, but he'll receive them, or he or she will receive them, hold on to them, and then upon the expiration date, they'll take their pile of written requests to remove my signature, and as they start going through the certification process, they will say, here's a written request from Brenda Robinson, strike her name from this, she doesn't count towards the 2,000.
Well, my fear of that is if a petition came through like the last one did, where there was very little leeway in petitions that were not valid, and I think that it's probably is some responsibility for the clerk to let the agent know that I've received 50, documents requesting that names be removed, because that may take them below the threshold.
And that's precisely my point. It seems unfair to the agent if they have 2,011 signatures, and Merton knows that there's 20 people who have rescinded their signature. There's no way that the agent would know that they are in a deficit.
Well, they could check. I mean, it's public knowledge. They could walk into Merton's office on day 27 and say, hey, how many, withdrawal requests have you received? And then, there's the good old, hey, you should really be shooting for more than the amount, just like we do when we all applied here to run for this board or commission, because, someone who signs it might not necessarily be a Kennybunk resident.
Right.
Right, okay.
So-
I just want to make sure that we're being fair to the
Yep. I think it's fair. I don't think it's.
recall folks, and that we're not saying, surprise, you don't have enough at the last minute. That seems disingenuous in the process.
Speaking for Janice and I think we would agree with that, and there's no problem putting another sentence in here saying that upon receipt of a request to have your signature stricken, the town clerk shall notify the agent of that fact within 1 business day or something like that.
Merton, how's that?
Sounds fine.
Oh, okay.
No, just for historical interest, I think last time, the only real, what I would call formal requests for removal of signatures were maybe 3 people. And certainly towards the end of that process last time, a lot of people were having major issues with the way it was being handled. So,
Yep.
I mean, it may be not as big an issue as maybe we're thinking.
Okay, thank you.
I've got Brenda, then I've got Gail, then I saw Chris's hand in the air.
I think some responsibility needs to be put on the shoulders of the person collecting signatures. Yes, a process for withdrawing your signature is fine, but having Merton bend over backwards to make sure that all of the signatures are valid. I mean, he goes through a process, but if you're out there collecting signatures, it's your responsibility to tell people what this is for and be honest, which we know did not happen. And if you want to come in early and find out, that's a burden on your town clerk. That's a big burden in a big process. If you're going to collect signatures, you make sure those signatures are valid. That's your responsibility, or my responsibility if I'm collecting them. You ask people if they're a registered voter in Kennybunk, do you know what this is about? That's pretty normal.
Gail?
Chris, if I could
Yep, go ahead.
just digress for a moment here and let people know that this No Labels party that was started and started in Maine, and they need 6,000 signatures. Well, they actually got 88 people in Maine, in Kennybunk, to sign what they thought was a petition, but they were actually signing enrollment cards. So we were obligated to take all those people out of the party that they were in and put them into the No Labels party. Fortunately, our Secretary of State sent a letter to all 6,600 in Maine that did that, and at least 40 of those people now have come to me, and we have put them back in the party. They had no idea that they were signing an enrollment card.
I don't even know anything about this. Go ahead, Gail.
Gail Spofford, I'm just wondering what the form is going to ask, because they're going to have more than one person carrying petitions around for signature. And if you get 50, but I don't know how many signatures can you have on one petition? How many will hold?
I think last time we had at least 50 per petition.
Okay, well, you're going to have several petitions to look through for signatures. You have 50
Correct.
people who said, I didn't really mean to sign this because I really didn't know what I was signing. And you have to look through all the petitions?
Well, what we did last time, because it got so cumbersome, we actually entered them all into a spreadsheet and put them alphabetical so we could look for duplicates.
But shouldn't the form that, because this indicates there'd be a form they'd have to fill out, shouldn't it ask them whose petition they signed, who took that petition out. If they have, it has their signature somewhere on it,
Right.
right?
Right.
So if they really want to do that, shouldn't they have to tell you which petition it's on? So that would cut down on the time where you had to go back and
I
take that.
don't know
Well,
if
also,
they
the
would
reality
necessarily
of the
remember
situation
that.
is, too, is that most of those petitions are going to come in on the last day.
Yeah.
I mean, I think out of 28 individual petitions, I think probably 28 of them came in on the last minute of the last day. So, you know, we've got to sort
just
of
trying to
figure
help
that
you out here,
into.
Martin.
What's that?
I'm just trying to help you out.
Yes, I know.
The form itself might be important to the
Yes.
process.
Oh, yeah, I'm sure, and as I think I'll echo what Merton had said previously, in that the last time there were 3 individuals who actually did this, and I appreciate that Merton even signed himself up to, or the future town clerk, if it ever happens, to email the agent when they actually receive one of these things. I personally think that's a little above and beyond. I think it's not hard for the agent, if they're serious about this, to walk into the town clerk's office and say, hey, how many of these things have you gotten? So, my 2 cents. Chris, you had your hand in the air after Gail.
Yes, I have a petition here to help baby deer preschoolers in the environment, and I would like you to sign it. It's pretty complicated to read it yourself, but if you'd sign this quickly for me, we can get those signatures in. And by the way, if later on you find out something, you can rescind your signature. So please sign here quickly. That's, well, it seems to me that's a reason for people to sign a petition that I had hoped we would be making harder and making voters realize there's a consequence to signing a petition, and that they should say no until I know more. But I think this kind of flies in the face of that, and the reason I'm also, I mean, it can be done. I think it's, if we put a really precise date on when future requests are not valid, and that's held to, then it can work. But I think we're associating the misinformation is only on the part of the petitioner, when the misinformation may be on why you should rescind your signing the petition. So, I mean, where you want to put your trust, that's a tough one. But, this isn't enough for me to vote against the process, but I am not really in favor of rescinding signatures and letting people get away with having no responsibility for signing a petition.
Go ahead, Stephen.
Actually,
Go ahead, Martin.
yeah, Chris, I would want to say to you on that is that probably throughout that entire process, one of the most difficult things for me was having to tell a person who was really, really, distraught about his signature being on a petition where he was misled, and letting him know that there was nothing I could do is a very difficult thing to do.
Well, I was going to say, is it the collective view here that this is important enough to go in the town charter? And having just heard what Merton said, my conclusion is, yeah, it is important enough for the reasons he stated.
Yep. I 100% agree with what Merton said. And knowing that there is evidence already of, with the recent recall, people who were presented with a false bill of goods and said, sign here, it has happened. And the only thing I worry about that I don't think we can solve for, because the process has to happen and continue, is just that people might sign and have a very limited window with which they can go be informed and withdraw their signature. But I don't think we can solve for that. I'm going to stick a fork in that one and say the process has to move. So go ahead, Brenda.
If a husband fills out the income tax forms and says to his wife, sign here, and she signs here, and submits it, she's not off the hook. As the spouse, she's not off the hook. There is, and I agree with Chris, that there is a level of responsibility for to the person who signs to know what you're signing. And that's, the more we try to be, what's the word? I don't know the word I want. The guardians of things, the more we enable people to be irresponsible. And I really think we shouldn't go too far. I think having a recall or being able to take your signature off with a limited time might be okay, but it's the responsibility of the agent to present it correctly, and it's my responsibility to know what my name is going on.
Yep. Miriam?
Miriam Whitehouse. The problem I have with that, Brenda, is that look at the world around us and look at the barrage of misinformation that people are subjected to. I think it's great to think that people need to be responsible on both sides. I don't think it's going to happen. And I think that people are lied to and they believe it. And I think it's really important to give them an opportunity to correct a mistake if they discover they've been misled.
Thanks, Miriam. All right. Any other questions, comments, concerns on certification of the petition and notification, section 706? Seeing none, we'll move on to a proposed new edition, section 707. This came up in conversation previously about what is the status of the elected official during a pending recall. Open the floor for comments. Dick?
About a third of the way down, in the left gutter, it starts off exceptional circumstances. The select board determines that when exceptional circumstances exist, that may justify or require temporary suspension. What's an exceptional circumstance? Somebody's exceptional circumstance may be somebody else's non-exceptional circumstance. I think it needs to be fleshed out at the very least as to what we mean there. And because from moving on from there, the select board asks the person to resign, and if they say no, then the board of select people can suspend them. Which, all because they decided something was an exceptional circumstance. I don't know what an exceptional circumstance is. I think that's varies in everybody's mind.
Yep.
So I think that needs to be tightened up a great deal, especially if we believe, I think we all talked about that we shouldn't be just suspending people while the process works itself out.
Yeah. I'm going to jump on Dick's comment and just say, based on the previous discussion we had about innocent until proven guilty, et cetera, I am not a fan of this entire section as a whole, because we have seen the recall process weaponized already, and while the threshold is high for it, I wouldn't say that it could never happen again. And I think if we make the process potentially judge, jury, and executioner, especially when it relies on a limited body of people to be that judge, jury, and executioner, I get very nervous about letting the process dictate things to happen before the election actually happens. Because keeping in mind that this, and again, I'll point out the distinction between, in my mind, that recall is a tool of the people whereas forfeiture of office, as it was proposed, is the tool of the select board. So when I see there being discretion left up to the select board or the legislative body in this section, it makes me concerned that they could potentially, that we might be merging things, and if you want to.
Yeah, you'll recall that in the initial versions, we were concerned about the Elliott Cutler potential scenario. You can't have a person like that staying in office, exercising public duties, participating in the decision-making process. So you could have a situation where there's a presumption that there's going to be a temporary suspension. The commission rightly decided that was not what it not the direction it wanted to go in, and so this is just a suggestion as to the way that the alternative could look, a presumption that you stay in office, but in the Elliott Cutler kind of thing, you know, you've got computers that are seized, and there isn't any question as to whose computers they were or what was on them. That's a situation where you can't have that person remaining in power. So what kind of procedure do you set up to address that sort of a situation? And I don't think either Janice or I had any exclusive grasp on the way to do that. I mean, this is just one potential way to do it. And we were concentrating upon preservation of the due process rights of the person who is actually temporarily suspended.
Yeah, I appreciate the effort that went into it, and sometimes it's easier to see things written and then come to a conclusion than just talk about them and say, oh yeah, that kind of makes sense. So thank you. Ted?
Yeah, this gets into the issue we've been going to all along between a sort of legal and a political process. And mixing them up is what we've been dealing with through this whole thing of how to do that. And that when you say exceptional circumstance, I'd agree with Dick, that's a political term, and that could be used politically. So in effect, because it's not defined legally. And it would be very hard to define that. We could have 10 pages of definitions maybe to define it, unless there's something in the statutes that says that. I would strongly doubt it. In which case, this then opens up for political process, which is something we're trying to keep out of this, an extraneous political process, if I may add, and that's what's happening. At the same time, we want to protect the institution or protect the people who are being attacked, and so and that's always the tricky thing. How do you put the legal and the political together when one wants ambiguities and opportunity and the other wants precision? And that's a hard one, and it comes up here.
Brenda, then Miriam.
I guess it seems in my head that the status of the elected official during recall is the power of the people, but it isn't a criminal kind of thing. I can see this paragraph or something like it definitely in the forfeiture section, but I have trouble seeing it in a recall when the grounds for recall aren't the same as forfeiture. Nobody has been proven guilty, and the person, as has happened in our previous recall situation, stayed on the school board or whatever because there wasn't any proven malfeasance. Is that the good word of the day?
Mm-hmm.
That's what comes to my mind.
Miriam?
Miriam Whitehouse. I totally agree with that, and I would also agree with your concerns, Ted, about opening the door to politicizing things, because select boards come and select boards go, and you have to write this in a way that it would protect somebody from a political board, which we've had in the past and I'm sure we'll have in the future.
Chris?
Well, we just had a great deal of discussion to not give petitioners an extra day to get a person out of office. And here we are proposing that he be taken out of office by the select board. I mean, this is big
Yep.
compared to what we were just talking about.
Yep, fair point. Go ahead, Janice.
Well, it sounds as though pretty much everybody would stay away from this. Is there consensus to put something in to allow the person to stay in? I mean, we can write it any way that the group feels it's appropriate. I think we need something in here to address what happens while this is going on.
What
You know,
about what's
I
in
know,
the
and there's two
current?
sides. You could have someone who did something really bad versus not so bad. And how do you determine what's too bad without defining it? And I don't know, that's tough, just like Ted was saying. You want to protect the town, but you also want to protect the integrity of that person's reputation until it's proven. So would you guys like to lean toward keeping them in place until the situation is resolved?
I personally think it doesn't even need to be mentioned, because I would like to think that looking at the totality of forfeiture of office combined with recall, that, you know, what is it? I guess not exceptional, gross malfeasance, whatever, hopefully would be handled by the forfeiture of office. If we're talking about an Elliot Cutler situation, I would hope that the select board would go through the process that's outlined in forfeiture of office to remove that individual expediently. Or, I mean, and keeping in mind too, you know, I think the thing we have to remind ourselves frequently is we're talking about a town of 11,000 people here. You know, this person has to show their face in this room to a group of their constituents. It's not George Santos or going off to Congress and being in DC away from his constituents, you know, for weeks and weeks and weeks, right? So they have to show their face in this room, or, you know, they're gonna ultimately get axed for one thing or the other. So go ahead, Janice.
So theoretically, you could have both a forfeiture of office proceeding as well as a recall at the same time.
You could.
Right?
You could. One would like to think, I think that the forfeiture of office would be more expedient
Yeah.
and cost less money.
But theoretically, it could happen, right?
Yeah.
Okay.
So I personally would say exit out. I don't think you need to stipulate that. I don't think you need to put a section in here that says, well, a recall proceeding is happening, the targeted individual shall remain in office. I mean, I guess it wouldn't hurt, but I think if that would be the assumption. Go ahead, Durwood.
Yeah, I guess I've maybe shifted my position a little bit on this, in that I see a lot of problems with the hearing that a select board would conduct, and, you know, what are the due process rights, and what are the standards, and you know, what are the remedies afterwards? So it is opening up a big can of worms. I think that forfeiture gives a kind of immediate remedy. If something is serious, it probably would fit into the forfeiture category, and you can move quickly on that and remove the person that way. I still would like some clarification on whether there's any other steps, because there was an incident years ago and where there was some alleged bad behavior, and the recommendation of the, I think came from the town attorney at the time, was to strip them of all it was a select board member of committee assignments. I mean, is that something, you know, is there an in-between thing? Because I don't know where that came from. I don't know where it comes from in law, or if it's just something that was developed. I see Natalie, seems like she has something to say on that, if you're curious to hear her.
No, I don't have anything to say. What I have seen done is that a select board can reprimand a member. Now, of course, that doesn't really have much legal effect. Whether it has any political effect, I guess, is a different question. But there isn't anything in the law that apart from charter provisions, that would allow a select board or any elected officials to take some sort of disciplinary action against fellow elected officials, unlike appointed officials who they can remove for cause. There's no provision for someone who's elected.
Thanks.
So maybe there's some in-between steps. I know it's been discussed. I don't know if it was implemented, and maybe it's just too complicated to get to that. And the whole situation is just dealt with in terms of forfeiture. I am concerned about moving this process forward too, and I just think that, you know, we've talked and talked and talked, and you know, I think we ought to, you know, not let the, what do they say, the perfect be the enemy of the good. You know, we gotta move this. And
I think, yeah. I think you start getting into stripping committee assignment or anything like that, that's going to be a very long, arduous process that kind of gets into
agree.
the previous point you had made a few weeks ago about types of criminal offenses and everything like that, and that we need to write a 300-page charter to list out all the potential
regulations.
violations. Chris?
Yeah, I appreciate those comments. You know, presumption of innocence is aggravating as can be. But it is so basic to our entire existence as a democracy. You know, it's tough to say better that someone guilty go free than somebody innocent be convicted. But that is our system. It's not, you're never declared innocent, you're declared not proven guilty. So when something demands a subjective decision and it's not cut and dry, I'm saying, I'm not even for forfeiture. If you look at most of the municipalities, it says conviction, conviction, conviction. Some of them say felonies, Kennebunkport. Some say, you know, more than 30 days, whatever, but it's still a conviction. That's cut and dry. It's not an elected board making a political decision as to whether this person should be on there or not. What is possible, I think I mentioned long ago, Janice just reminded me about like the speaker in the legislature or somebody who is the head of an assembly has the powers of presiding over that assembly. As far as committees are concerned, they do have censure and reprimand. If there's a violation, you know, I've been thinking about, should we put our ethics provisions in forfeiture or something? But, you know, talk disparagingly about a fellow member, somebody's going to be forfeiture for that. I mean, it may not be great, but to take away the people's choice because of something that may be disputed. So that's why I'm saying it's really tough to have presumption of innocence. But I think we get into some really sticky wickets here if we adopt 707.
Okay.
So.
Yeah. All right. Cool. Moving on. Section 708, the recall election. New paragraph was added. Designed to ensure that a recall election doesn't happen with a bare minimum of voters and included as part of amended LD 1443. Questions, comments, concerns? About the whole section, not just the amended part.
I think that's maybe a tough threshold,
Yeah.
because even with the controversy of the last, or the only recall that I've been involved with, I think the count was 2689 or something like that.
Yeah,
How many people voted yesterday? 2,000?
2,000-ish.
1,632.
Oh. It's a great,
Yep.
I think 4,000 might be a little high.
Yep.
you know,
Stephen and Janice, would you work with Merton to maybe come up with a threshold that Merton feels is attainable?
Yeah, I can easily give you 25-year history.
How about we,
Yeah, go ahead.
why don't
Rick.
we fix it to something like the last presidential election or something like that?
Well, no, you don't
Presidential's
want to do that
usually
because
big.
Or the-
that was almost 8,000.
Right.
Okay, fix it, can we fix it to something so we don't have to adjust it every 10 years?
Right, like a
Then it'll
percentage.
slide, Yeah. Percentage of,
How many registered voters are there in Kennebunk?
As of
About
as of yesterday, 10,683. I just looked at it.
83.
Just for comparison purposes, for purposes of passing a charter provision, the statute requires that it be 30% of the people who participated in the last gubernatorial election participating in the election in order for it to take effect. Even if it has a majority, if it doesn't meet that threshold, it doesn't take effect. I think that's what you're trying to do here. I don't think, that's not necessarily the numbers, but that's how it's done for the charter.
Because it would be very simple for the person who's being recalled to ask everyone not to go and vote.
So the percentage who voted in yesterday's election was a little bit more than 15% of
A little more than 15.
registered voters in Kennebunk. And I think June is the lowest turnout typically,
Well,
right? Other than
it was
special.
also because there was no state election. And really a ho-hum cast of, not the people, but the numbers of people running for the offices.
There weren't a lot of contested things.
Right.
Yeah, uncontested.
There was only one.
Yeah.
it seems,
Go ahead,
it
Roy.
seems counterintuitive to tee up an election and go through all the significant work of the staff and the volunteers, and then have it be said at 11:05 or 8:05, oh, that didn't mean anything. I mean,
Yeah.
it didn't, you were 10 votes short of the number of people. I mean, we just wasted thousands of dollars on something that is a nullity. I mean,
It's a good point, and I would point out that the petition requires 2,000 votes, 2,000 signatures, which is less than what actually turned out at the election yesterday, and historically was kind of the same as in a way, the last recall election. They didn't even get the votes that they had for signatures. So I would say that 4,000 is, I would agree, a high threshold, and maybe peg it to either a lower number.
I like Natalie's, when she was speaking about the 30% to amend or to, you have to have that anyway to create the. So, I mean, I think that the 30% is probably not a bad idea, but instead of putting in a percentage, maybe it probably should be, 3,000.
So that's 30% of the last gubernatorial?
That would be 30% of the current registered voters.
Oh, wow. Okay, so that's 3,000 and change.
And remember, that number doesn't really fluctuate a lot. Or hasn't for
But
the last
I think
6 or
it's
8 years.
much cleaner. I love the fact that Natalie has shown us a threshold that's already in state law. So if we approximate that threshold, I think that's legitimate.
Yep.
I mean, I kind of am with Durwood here. I would hate to have an election come up 10 votes short. So I'm not even sure we should have it. But if we have it, I think having a 3,000, because if we clear the rolls and all of a sudden it's 9,500 voters instead of 10,300.
Yeah.
Or something, then that number does change a little bit here and there. So to have a concrete number like we did for petitions, I think is a great idea.
But also, I can tell you historically, I know of at least 3 times that amendments did not garner the 30%.
Really?
Those were single-issue amendments.
3,204.9 voters. It's 30%. So 3,205 if you want to,
3,200 and what?
3,205. That
Alright,
would be
so we wanna-
30% of the
That's not
registered
what you're
voters.
proposing, is it?
Yeah,
No, I don't.
Well, no, I mean, if we're saying 30% and we want to translate that into a fixed
But
number.
you're assuming that the current number is what the number is going to be, or what
Right.
the number has. I think a nice round number is easy for us.
Oh,
and-
oh, sure. I was just saying, that's exactly 30% of the registered voters. Go ahead, Ted.
We were putting the numbers in on the question of signatures because that was important in signatures. Here we're talking about a vote, a little different, and it seems to me it'd be a lot simpler just to reflect what's in the state statute language routinely. I'm asking your opinion, Natalie, on that thought.
Do you mean as to how the vote is calculated? You mean, so 30% of the participants at the last gubernatorial
Just
election?
what you said, that's, if that's in the statute, then.
Well,
then-
that's in the statute
Yeah.
for a charter amendment, and so that's what this board is going to have to get to support what's going forward. I just simply stated that that's what it was for that, and that you might want to think about, again, I'm not recommending any numbers at all to you, but I know you've been working with Merton to determine what the actual numbers are, so that you don't have to recalculate it each and every time.
Right.
And so Merton is saying that 3,000 is approximately 30% of the voters in the last gubernatorial election. And that would also make it consistent with other provisions of this that set forth actual numbers instead of having to calculate it differently every single time based on the last gubernatorial election.
I misspoke. Can I just clarify?
Yeah, go ahead, Chris.
I forgot your. I was concerned with the variant of how many registered voters we have, and that's not what we were talking about. We were talking about the voters in the last gubernatorial election. Right.
Correct.
That is a concrete number. 30% of that is easy calculated. So I'm less concerned about that, but I still think 3,000 is a nice round number, but I'm fine with either one of those decisions.
Dick?
It seems to me that spending all our time picking the differences of numbers at our meeting here, it isn't as productive, especially since we're planning to have public workshops where the public can weigh in on it and perhaps help guide us to a specific number or a number that will work. Because in the final analysis, we can write whatever we want, but if we can't convince the people that they ought to vote for it, then we spent the better part of a couple of years here beating ourselves over the head that for nothing. And it's like when we do zoning amendments in the planning board. If you do a zoning amendment that's so onerous, that nobody's going to vote for it. There's not going to be a change. And so we have to be careful that we don't create a document that is not going to pass. And sitting here trying to pick a number, it seems to me we pick a damn number and we go forth to a public workshop and let the public help pick it.
Yep. 3,000.
3,000.
Boom.
Okay.
All right.
3,000 it is.
Not 4,000, it's 3,000. All right. Other questions, comments, concerns? 708. Seeing none, section 709, recall election ballot requirements. This is the wording for what goes on the ballot, and other replacement candidate was added. Was that as a write-in option? Okay. That's a requirement. Yeah. Thanks, Martin. Go ahead, Susan.
Is there a requirement to have the office listed after the name of the individual? I'm hoping that voters would be smart enough to know what this is all about, but you never know. But, it would say, Joe Blow's Select Board or RSU School Board.
Like, should name of elected official followed by their position, office?
By their office.
Yeah.
Easy fix.
So one thing I wanted to question is, if your vote is yes, then please indicate who below should replace for the unexpired term in his or her office. I'm pretty sure you vote, or the intent is that you vote for a replacement candidate irregardless if you're voting yes or no. But that is no?
If your vote is yes, then you should indicate who the replacement candidate should be. If your vote is no, then you don't need to designate a replacement candidate.
But
No.
you might not prevail on your side
ex-
of
ex-
the person
exactly.
not being recalled. And if you don't, you should still have the right to vote on a replacement candidate. And in fact, the way this is set up, the replacement candidate can be the actual person who's being recalled because there's no prohibition on that.
Doesn't our current charter say that they can't? No, really? I thought it said that the replacement candidates cannot be the candidate being targeted
Good
for a recall.
question, it may be.
Pretty sure it is.
Okay, I'm gonna look at it.
Go ahead,
Take Nelly's
Chris.
advice on doing that.
And I'm against this entire section. I told you earlier that the question of a recall should be yes or no, that's it.
Oh.
And if you are saying, as a Democratic Party, let's get rid of, and I'm a Democrat, so I'll use us as a villainous motive here in this case. We have a Republican office holder. Let's have a recall. We'll put a popular Democrat on that, and the question doesn't become the recall. The question becomes, do we want this guy or this guy? That's kind of interfering with the two-year election or three-year election process.
Christian.
So for me, I know people say, well, there's a time period then for when you would fill the position. But folks, I mean, we have a 7-member select board now. A lot of people say we should have a 5-member select board. So if we don't fill a position for 3 months, big deal. I mean, you know, the majority number doesn't change. So I don't see consequences to this, but I think that if you're really talking about a recall election, you should keep the issues to whether the person should be recalled.
But what happens, I'm sorry.
Go for it.
Could I ask a question? Sorry.
Because I was gonna ask it.
Because what happens if all 7 members are subject to recall? And what happens if all 7 get recalled? And it has happened in municipalities
I can
where
answer
a
that.
majority,
I
you
obviously
represent one,
didn't.
don't you?
Want to reply to
Or
that.
represented one. And so at that point in time, you have no elected officials. Who calls the election?
Yeah,
Who does everything?
I did, the town, all elected officials were recalled, and so we had to go to the Cumberland County Superior Court and have the clerk have appointed with all authority to run the town.
Yeah. And I represented a
the
town
election.
where
No, thank
3
you.
out of the 5 got, 3 out of 5 got recalled.
All right, I had Merton lined up
Yeah,
and Ted.
Chris, I think it's
Gail.
just really a very bad idea because that, particularly if we went school board, if they stay on here, that they can be recalled, you're going to go months without representation, and that's just not right. I mean, because you have a certain number of people who are representing the town of Kennebunk, and they're needed there to represent the town. And it can take, depending on what you put in the charter, it can take several weeks or months for an election. And it might even be 190 days if the election, if that's how it's worded, and that's the next, election that we're having, either be it the annual or a special in November. So that time could really be long.
Well, I think it could be worded to avoid that, but I hear you.
We have to have nomination papers, blah, blah.
Ted?
Yeah.
I can understand, and I agreed when we had this earlier discussion, that the issues of how do we replace, it's an operational issue. At the same time, the way it's worded here, if I'm just Joe Blow out there voting, I say, good, I like Peter rather than Paul, I'm gonna, this is an election. And that I think this is a recall. So I think Chris has a point on this, that we're talking a recall, not an election. But at the same time, we have to cover these other eventualities that would be cause even greater problems. So I'm sort of wondering if there's some way of making that distinction here, so we're looking at this and say, okay, yes, here's my candidate, I have an election, and that's not the point. And so if we could somehow separate that in the language or some way so that we can keep the governing operation going if everybody's thrown out. At the same time, keep a recall election away from being a election. That's my only concern. I think there's a point here, but we need to think about.
You know, when I was expressing if your vote is yes, I don't think that's true. And I know I had mentioned this earlier, or like meeting a while ago, but I think the lead-in language is that I was thinking was more along the lines of, in the event that the candidate is successfully recalled, who would be your replacement selection, something like that. And I can email that to you guys, and you
Yeah.
can ruminate on that. Gail?
Gail could certainly.
Gail Spofford. Is there a way to void the names at the bottom through the ballot machine?
No.
We did have the option, okay. For the first time, I can't remember the last time, we used the weighted average in our last school board meeting. And Kenny Bunk's position prevailed every time. Go team.
Okay.
Because we outnumber the other communities in our votes, number of votes. We have 98.
Yep.
Kenny Bunkport has 69.
Yep.
And Arundel has 68, I think. So if you were to strip a Kenny Bunk member.
If you were to what?
If you were to strip a Kenny Bunk member of the right to vote because they had to forfeit the office while this whole thing happened, or there was no, if the recall was in a Kenny Bunk, there was no one to follow up with after that, we would lose those votes.
Right.
We don't use it very often.
Yep.
But someone called for the weighted vote, and Art had to get out his calculator and figure out what it was.
Gotcha.
But currently, and I know 20A says this, I don't know what 30A says, but the select board has the right to replace someone if there is no one else on the ballot, if the recall prevails and the seat is then empty. That's not necessarily a good idea. At the last two times that's happened, I think you got good candidates because the people who volunteered to fill in and were chosen were people who had extensive background on the board, and it came at a budget time, and both times there were people that had been on the finance committee for a long time. So that way we were lucky, but you could end up with someone, or only people who wanted to volunteer to do it with good intentions, but no knowledge. And that would not be good for the board, for the students, for the staff, or for the community. So I personally think that you should have, if you want someone recalled, you should run a candidate. I was appalled that the recall people did not run a candidate last time. We really thought they would. And quite frankly, that's the only reason I signed up to run, because I thought they would run a candidate.
Yep.
And we were so unhappy with their position that we didn't want that position to prevail.
Understood.
And also, this board recently had an issue with a board member, and we had no policy to allow us to act upon that. And the head selectman for that community was in touch with me to see if we had policy, and then asked how we could avoid that afterwards, and there really is no way to avoid something like that happening again. MSMA does have a policy with regard to those things, but their recommendation is don't use this policy, and we don't have it. And in the policy book, it's kind of grayed out. It's sitting there in their book, but it's grayed out because it's a double-edged sword, and it doesn't necessarily solve the problem. And all it really does is provide you with the option of removing a chair and removing committee chairs, or removing someone on the board from the policy. So it is sort of a sticky issue, but I think if you want to recall someone, you should run a candidate, and then the people who don't want the recall should have the opportunity to run a candidate.
Well, I don't think we can force people to run a candidate, but go ahead, Dick. go ahead. And
Yeah,
then
but
Susan.
the only thing I'd say on 7.09 is that they be separated, two separate questions. In other words, right here, it's a question with two answers. You should have the recall and the results of the recall as, say, question 1 on the ballot. And then question 2 on the ballot should be, you know, if question 1 prevailed, who would you vote for, Fred or John, or whoever? It should just be separated as to two separate questions on the ballot. Because here, tying it together creates some of the issues that some of the people have been discussing. And I think if you separated it, it would, they deal with one, and now they move on to a totally separate question.
I could send you a ballot that we used last time that really didn't raise any questions as to what people were doing.
Okay.
Thanks, Mayor.
Susan?
I was just going to say to Chris's point, that you thought maybe it would get down to a popularity contest, that it was an opportunity to replace somebody with someone else that the voter would prefer. You know, the issue at hand is the guilt or innocence of the ground or grounds that is the foundation of the recall effort. And people should be passionate about retaining that person in office, you know, whether or not that they've been falsely accused, retaining them in office or not. Not that this is a great opportunity to have another individual of their choice.
Go ahead, Chris.
I appreciate Gail's comments, and I actually had not thought of a multi-town board being negatively impacted by delay, which certainly would be the case. And so I understand that, and I mean, I do think wording could be provided for a quicker replacement in cases where that's the case and so forth. I think that what I was hoping for was a vote of yes or no with consequences. If we vote to remove, is this so serious that we'll go without, we'll have one less member on the board for 2 months? And what that might entail. In other words, is this serious? What I do think can happen, I understand what Susan said perfectly, and I hope that's true. But I do think there's opportunity, we're making it by, and it is the status quo. Offering replacement candidates is how it's done. But offering those replacement candidates makes recall easier. And invites political mischief, which we don't seem to have a shortage of in society right now. So that's where I was coming from. But I appreciate learning something today.
All right. So I do believe that the candidate or the person who is targeted by the recall is currently prohibited from running again, because I think this was, or running in the recall slot.
Right.
And I think there should be language around making sure that they can't just say, well, you went through all this process and here I am again, so.
Can I just say,
Right. Okay, so it is in the current one. Thanks, Stephen. It's section 704. Any official being recalled shall not be a candidate at the recall election. Thanks, Stephen. Right, and then the next one is the incumbent official shall continue to perform the duties of, so, go ahead, Gerwin.
I think that you're trying to do too much by getting the candidate in there at the same time as a recall. And we have a very thoughtful process here. We have a candidates night, has an excellent moderator that comes in and asks the candidates questions, and they have to go through sort of a process. Whereas this sounds like, you know, grabbing someone, throwing in, we get multiple names. It doesn't seem like a sensible process. And I could see a lot of gamesmanship going on with, as someone said, putting their person in. It doesn't seem like a thoughtful debate.
No.
Seems like they should be separate issues. Does the one person have to leave? Okay, if they do, then the select board could appoint somebody, or we'll have an election whenever it happens. I know it's not optimal, but neither is recall. But it seems like it's suboptimal to have just a kind of a scribble in type of thing. Am I gonna say, I'm running for select board in the event there's a recall? I'd like to submit my name. I'm a conditional candidate. I'm gonna put signs around town. If recall, vote for me. I mean, it makes no sense. I mean, I've never seen anything like it. It seems totally illogical. But-
Well, this did happen, like, not that long ago.
Well, did they, I mean, did people campaign, were they vetted with, you know?
Gail?
Well, no,
right
that was
there.
after,
No.
well, she was
This
replaced,
exact,
well, you had a candidate's night.
no.
The-
No, no,
the
no, no,
select
no,
board.
not when she was on the recall ballot. She
No.
was on the recall ballot.
It was haphazard. That was the like problem with it. But I think, in my opinion, I think there's a little inconvenient truth. You know, like, yeah, it's inconvenient that we have to do both at the same time, but I think Natalie and you provided a very excellent reason as to why. You know, what if everyone's targeted for recall, the recall succeeds, and then we have no government for
Right. And there's no less gamemanship in the recall process, having a candidate on here, than a normal nominated candidate at an annual town meeting.
Well, there's a process to be, you can be written in.
But a person on here has to go through a process. They have to go through nomination papers,
She still had to pull nomination papers.
or their
and
name
everything.
doesn't get on the ballot as a replacement. They have to get the same number of signatures. The time is shortened somewhat, but they still have to go through the process. I mean, so it's not like just throwing a name out there. I mean, they are nominated candidates.
I would like to try to get through the remaining sections of this tonight. Okay, Gail.
Push it again.
Gail Spofford, quickly. When someone runs to replace a person, and a recall would be replacing someone, they only fill out the rest of that year. So for instance, Arundel had an issue, that person resigned, thank you very much. And his replacement was nominated by their select board for the rest of this year. Then she ran for the 2 remaining years in that seat. So you still have part of the election process. And like Merton said, you have to fill out the paperwork, you have to get the signatures in order to run, to have your name on the ballot. So it is a small sacrifice of political gamesmanship on the front end.
Okay. Thanks, Gail.
I appreciate you asking the questions, though.
Questions, any other questions, comments, concerns on section 709? All right. Section 710, recount. Few sentences. I think this is pretty much verbatim taken from recount language. All right. Section 711, results of recall election. Questions, comments, concerns?
We would like a definition from Mert for what the town records book is. And you don't have to give it to us right this second, but maybe you can email us something for our
It's
definition.
just the town meeting book where all the official records are for elections, town meetings.
Okay,
You're welcome to come in. I'd love to show it to you.
okay,
It's a
thank you.
giant leather-bound tome, goes all the way back to 1820.
Yes,
Go ahead,
we
Susan.
do have them back to 1820, yes.
Merton,
Yes.
is this incorrect? The Book of Official Records of the Town, including records relating to town elections, that is maintained in the office of the town clerk,
That is true.
That
Peachy.
is Susan's definition.
So that can be retained, we don't need to,
I don't think it needs to
Modify it.
change, no.
All right, great. Section 7.12, limitation on repeat recall petitions. All right, no problem. Section 7.13, periodic review. We had touched on this earlier. I had made the suggestion that we elevate periodic review to the future charter level as a whole charter review at a certain time period, and then we capture the intent of this within that. Any, go ahead.
It seems vague to me, the review,
Yep.
what does that mean?
Well,
Does
I
it
mean,
expire?
what I've seen in other charters is that they actually say a charter commission shall be formed every 10 years with the intent of updating the charter, and thereby
That's more
allowing
specific.
the charter to be revised once a decade, or if we want to do it every year, I mean, I'm all for it. But
Well, what-
just kidding. Go ahead, Ted.
I'm all for the substance of this, and what we did was take out earlier the part about, who is, the town clerk discussion we had earlier. This is saying we need to review the charter every 10 years. That shouldn't be at the end of the recall thing. That should be the end of the charter.
Right.
That should be the final clause there in the end. So I would just shift it out of there
Yeah.
into.
That's what that was what I was trying to say by elevate, but go ahead, Natalie.
Yeah, I'll share an experience from another municipality that does have the mandatory review. They could not get any people to run for the Charter Commission this year because they don't have any issues going on, and they don't see any reason to spend their time on a
agree.
Charter Commission for a year or 2 years, when they don't want to make any changes to it. So I think the periodic review is a good idea, but I think maybe it doesn't need to be mandatory, or the revisions as to the numbers are mandatory. I leave that up to you, but I just wanted to share that experience with you. And actually, it's not the first time that mandatory charter review town has had that issue.
Got it. Chris, and then Susan. Select board decided. It's a power of the select board to. It was, no, it
Recall.
was recall, there was language updating, and then there's
Even if in our charter we say we have a 10-year review.
your mic.
Even if in the charter we say we have a 10-year review, doesn't that really mean that a question shall go to the people, shall we have?
It depends on how we would word it, I think. I
Charter
mean, we could
commission.
put in something that's every 10 years, the select board shall, make the determination or something like that, but.
Yes, you could do that. I would just remind you that the fact that the citizens say that they want it to be reviewed doesn't mean that you can get qualified people to run for the Charter Commission, or people at all to run for the Charter Commission, which is very problematic.
Remind me, I'm sorry, this, I don't know if I won't throw seniors under the bus. But I will ask you if the ballot on which we got elected asked if they should authorize a charter commission.
I thought
It's not for a authorization,
No, but I want to know, was there a question for the people to authorize a charter commission?
Yes,
So that had to be yes, and then our elections would be valid.
Yes.
yes.
Very similar to the recall.
Very similar to they followed one another.
Right.
The permission and then the election.
Go ahead, Susan.
And I need a reminder, when I read this, it seemed to me that, if you're futzing with numbers on a minor level, it would be an amendment, not a review of the entire document. And what I couldn't remember was what is the process for a tweak for an amendment if it's deemed necessary as opposed to a whole review?
Can I interrupt and just say, can we table that question? I mean,
Can
if
she
it takes
just-
2 seconds, go for it.
Answer it.
I don't think it's going to take 2 seconds.
Can we come back to it when we go through the actual charter periodic review?
I guess.
All right. Cool. 8:30.
What would you like to see from us next on this?
Okay. I think we strike periodic review out of there, out of the recall section. and plan to back burner it, elevate it in a subsection or another section of the charter where it makes more sense for the whole charter.
Right, I
And then
mean-
we answer the questions around
Yeah.
what is an amendment versus what is an entire charter review. And how does that come about? And I will send you the language that I proposed for the section 709. But I think otherwise we were striking 707 and changing the number from 4,000 to 3,000. And,
So I've got all down.
Okay.
I just want procedurally, Stephen and I will go through this, true it up. What is our next step? Should we just send it out to everyone
I
again
think
for
we
final
send it,
review?
I think we send it out to everyone. I think my goal next time, or our goal should be to go through forfeiture of office again,
Okay.
in a similar fashion we went through recall tonight, try to put a fork in that one, and then move on to a, vote as the group and say, this is our draft proposal, and then communicate that out to the public via, media channels and plan for a public hearing where we can focus on, hey, we have a draft of the recall article. Please come and join us and provide your feedback. That's how I have my head, but go ahead, Chris.
No, I just would ask that we, early in the next meeting, address some of the questions that I asked in this document. It's pretty straightforward. Part of it is multiple choice. I came up with every potential possibility that we could decide, but we need to decide one of them.
All right.
So if everybody could take a look at this and
Yeah.
we come prepared to
Yep.
carve it
Homework.
up.
Homework. Chris's handout before the meeting, if we'd review this, it talks about both forfeiture and recall, with the idea we're going through forfeiture next time, so we can incorporate that. Janice approached me before the meeting and mentioned that referendum initiative, public
initiation, yeah.
initiative and referendum is as you said, kissing cousin of recall, and that you and Stephen were volunteering to look at that language. I wanted to throw it out there in front of the whole commission and say, does anyone want to fight Janice or Stephen for that,
Get your.
that work? If you do, speak now or forever hold your peace.
Well, I don't know about forever, you know me. But I haven't read it yet. I was preparing this thing, so.
Go ahead,
So
Derwin.
just to confirm, we're talking about buttoning up the forfeiture and recall at the next
Next
meeting?
week, yeah.
Okay.
I just wanted to throw it out there before Janice and Steven start running with something else that will future be a draft, that
Okay,
no
I
one's gonna
understand.
be bent out of shape if they show up with a draft in a month and say, hey, I really wanted to do a referendum, so,
Yeah, I appreciate the work.
okay. Cool, so that's new business. We've got one more agenda item, consideration and approval of minutes. Make a motion to approve the minutes from the regular meeting, May 24th, 2023. I have a second from Ted Trainer.
Who made the motion?
I made the
Okay.
motion. Ted Trainer seconded. Open discussion. Comments, questions, concerns on last meeting's minutes?
Excellent.
Seeing none, thank you, Brenda. All those in favor of approving the minutes? All those opposed? 0. All those absent? 0. Passes 9-0-0. And with that, do I have a motion?
Motion to adjourn.
All right, I got,
Second. Second.
Ted finished first, Dick finished second. All those in favor?
Aye.
So that was Ted and Dick.
I'll give him the signed version here.
Thank you, everyone, for getting through that.
Chris, just for the record, I will be in Ireland at the next meeting, so you know in advance I will not be here.
Slancha, thank you.
Right, no Wi-Fi where I'll be.
Yeah.
Oh, really?
No Wi-Fi.
Yes, I'll make